Welcome back to our weekly immigration podcast. This week we're going to talk about a couple things that have occurred. Number one, we're going to talk about a Supreme Court case that was heard by the Supreme Court last week. I'll update you on what's happening with that and give you some more details. We're also going to talk about the Biden administration's lawsuit about H1Bs. They tried to dismiss a suit. We'll give you some details on that. And finally, we'll talk about the 60-day civil surgeon rule, which was implemented by immigration just recently. That's a benefit for some of you. At the end, we're going to have a couple of questions from viewers and maybe an immigration story. Check this out. All right. So the Supreme Court is in session right now, and they do hear immigration cases that have gone through the entire system. The case they're hearing right now is about an individual, Mr. Patel, who is basically saying, hey, I'm eligible for a green card under the law 245I. 245I is an old law from President Clinton days, and he filed a case showing his eligibility. He had a citizen son, I believe. He has 245I, and he's eligible for a green card because he entered the United States or he has 245I, so he's eligible for a green card inside the United States. So he went through the process and was actually denied. And the denial was, hey, you actually got a driver's license, whatever, 10 or 20 years ago in Georgia, and when you did, you checked one of the boxes or it was automatically checked for you or something like that, that said you were a citizen. Now, Mr. Patel is sort of saying, well, I don't recall doing that. It might have been a mistake or it might have been something very small, but I didn't really claim I was a citizen. I was just getting a driver's license. But this whole box he checked and citizenship thing resulted in him being denied by immigration, going to immigration court, being denied by the judge, and then being denied by the Board of Immigration Appeals, which is the appeal process after you get denied in court. And the part here that really, really matters is the judge in the higher court, immigration court, basically said, hey, we're not allowed to even look at this. We're not allowed to check whether it's a discretionary denial or not. We're not allowed to delve into that. And what these attorneys did, and I took a look at it, it's really well done, is they said, hey, look, when you look at getting a green card, and you look at this word discretion and the way it's written in this statute versus another statute, they pointed out that the judges actually should be allowed to look at the whole case and make a decision about the entire case instead of saying, no, immigration said he checked a box and they've denied it, and that's all we can do is look at that and say that it was approvable or not the way they did it. What I'm really getting at is the Supreme Court has to decide whether judges are allowed to look at the entire case and exercise a statutory discretion that was given to them by Congress, or whether or not Congress actually did give that kind of discretion to the judges, okay? Now, this is actually a really, really big deal. Discretionary denials and the ability to get that fixed has been one of the biggest difficulties in immigration law. It's a difficulty because you got a guy like this, Mr. Patel, who's actually clean. No crimes, no nothing. And in immigration law, he's eligible for a green card. But what they're doing is they're taking discretion to say we're denying you based upon these other factors. So really, really big case coming through. Supreme Court heard. There's a lot of questions and answers. And we'll be hearing more about their decision in the future, and we'll be updating you on that. So definitely stay tuned. It is a big immigration issue, and it could affect a lot of cases in the future. All right. The Biden administration did file recently what's called a motion to dismiss a lawsuit. Now, the lawsuit that came through was a challenge regarding the existing procedures and H1Bs registering with more than one employer. Now, essentially, when it comes to the H1B lottery, if you have an employer, the employer can register you. They can say, hey, I want to give an H1B to this guy. And this is the new registration process which came through within the last couple of years, right? And essentially, what they're saying now is that one individual can have multiple employers and still register under those different employers and therefore have a better chance at winning the lottery, right? If every one individual has a 25% chance of winning, by filing it 3 times, you get to have multiple chances at your 25%. So Biden administration tried to get that lawsuit dismissed. They tried to throw it out, and actually the judge denied it, right? So what we're seeing here is more litigation around all these H-1B rules that have come into place and how they're going to play out for you. We should have more information on this actual case before the lottery coming up in March. So check back with us, and if you want more information on it, send us a little chat. We'll let you know what happened. Right now, the Biden administration tried to close it. Case is not closed. It's still going. All right, we got an update on USCIS. They've noted that the requirement for a civil surgeon's signature right before you file your green card case is going to be waived. So what the deal is, when you file a green card case, normally you have to put in there your actual civil surgeon's documents with his signature. And the rule is, on the day you file it, that signature must be fresh within the last 60 days. Just a way for them to say the forms have to be very, very recent, that are signed by the doctor. One of the problems I think we have all the time here is doctors are delayed or backlogged, or sometimes they make a mistake on those signatures. A lot of times doctors forget to sign it. Anyways, USCIS says they're going to temporarily waive the signature requirement all the way till September of 2022. All this does is allow people to file their cases quicker without waiting through numerous delays and whatnot, and it's a streamlining in the process. I really like this because we know that immigration has its own problems, and waiving some of these really, really small requirements just makes the cases move along faster, and I think it's one of the goals immigration has. So that is good news that we're seeing right now. All right, got a couple of questions here. Does requesting your FOIA have any impact on anything like my pending N-400? The answer to that is absolutely not. Filing a FOIA means it goes to the FOIA office, and the FOIA office engages a system where the file is pulled and they get to do everything, make a copy of it and send it back. You know, the number one way I think files are pulled and get delayed is when you have the ombudsman get involved or your congressman get involved. That actually takes the file out of circulation and gets in the way. In terms of an N-400 or something like that, a lot of times I do time that out with my client and talk to them through it, because I mean, immigration isn't necessarily delayed, but I like to have one procedure and get it done and maybe go to the next one. All right, we got another question here from TikTok. It says, I filed the extension 2 months ago, previous EAD, I-94, can I still expire it? Yes, you can. You can work for 180 days. Should you file your extension on time? So extension filed on time, go to the USCIS website on the I-9 worker, and they'll show you how you can actually walk through and get your case filed and get your case filled out. All right, so those are the questions for today. Bottom line, I've got a simple story for you. I'm going to relate real quick. I had a client married since 2011 to an American citizen, and they still haven't filed their immigration paperwork. So I found that really, really amazing. I went through it with them, and it turns out a lot of their hang-ups were really simple. Well, we weren't sure about this, we wanted to wait for that. They just had a lot of hang-ups where they hadn't really even looked into it. She has this benefit called 245I. She could have had a green card this entire time. And what it comes down to is they had unanswered questions, and actually she was just afraid of something that happened in 2000. She was afraid of an exit and an entry she had, and we actually told her we have a way to investigate that. She kind of blew her away. We already filed the investigation, and we got the files back, and there's nothing there. Now, this is a strategy thing we have to work out with her, as in what her time in the United States was, when she entered, when she exited, and all that kind of stuff. But at the same time, you know, she's actually eligible for relief, and she waited 11 years and did nothing. So I was blown away. I get these all the time. I see people all the time. Don't sit at home. If you don't know what's going on, you got friends or family, and they've got something in their life or they're not sure of, you know, good attorneys will just check into it for you. They'll go get your file. They'll go investigate through a FOIA process just to see, is there something or is there nothing? But sitting at home and doing nothing isn't going to get you anywhere closer to it, all right? All right, guys, stay safe out there. Thanks for checking our podcast. You got friends or family who have questions, leave us a comment down below. Give us a like and subscribe, because we're constantly putting out free good content. Take care. Bye.